their regulations. They start with a fact pattern, and then they do questions. So it'll be question one, then answer one, then question two. In this case, there's 9 inquiries and answers. But the facts that they're all based on is this: residential real property is owned by record owner A. And the bar is just so damn creative in making these names. The property is to be conveyed from A to B and from B to C on the same day. Okay. So pay attention to that. That's important. You know, if you are a wholesaler and you're going to use your own money and you're going to buy that property and sell it the next day to someone else, none of this applies to you. You don't have anything to worry about. This is specifically directed at those transactions that not only take place the same day, but the sales price from A to B is 80,000. Sales price from B to C is 100,000. The money provided by C, C is your end buyer, would be used by B, B is you, the wholesaler, to make the wholesaler B's purchase from A, the seller. B, the wholesaler, would provide no independent funding. One lawyer, creatively named lawyer, would close both the A to B and the B to C transactions. Lawyer would represent B and C, that's the wholesaler and the end buyer. Lawyer would not represent A, the seller. Lawyer would be the settlement agent for the closings. So before I move on, that's wordy. Just want to make sure everyone's clear on what we have here. If you're not, put it in the chat. And I can't see the chat in my screen share, so someone's going to have to read it to me. But basically, you have buyer, seller, wholesaler. Wholesaler is buying from seller for 80, selling to end buyer for 100. Wholesaler is not using any of his or her own money. They are using the end buyer's $100,000 to fund their $80,000 to purchase from A, and then basically they'll pocket $20,000. And you know, this is a pretty typical wholesale transaction that we see. So I'm going to move on. I'm guessing everyone, oh, look, I can see the chat sometimes. Okay.
There's no questions in the chat.
Okay, good. So I'm gonna, good, because it's hard for me to pull it up. So I would like to not do that again. I'm gonna just count on you guys. Okay, so that's the facts. Now we'll move on to inquiry 1. Can lawyer represent both B, wholesaler, and C, end buyer in these transactions? And of course, that's the typical, right? You as the wholesaler generally want to bring these transactions to your attorney and have you your attorney close the transaction to your end buyer. And that's usually the way these things work. Well, now bear with me. I told you it's boring, but this first answer is the worst. It does get a little better after this. So here's opinion number 1, which is the same thing as answer to number 1. This scenario presents a concurrent conflict of interest under Rule 1.7. Lawyer's representation of end buyer may be materially limited by the responsibilities to wholesaler and vice versa. And then it cites some lawyer rules there, okay? So here's where we go into detail. Under Rule 1.7, it says that only time a lawyer can represent a client with a conflict of interest. There are times, in fact, in North Carolina, real estate closings, normal real estate closings, where you have, you know, a bank, a buyer, and a seller. There's the one area of law in North Carolina where a closing attorney is permitted to represent all 3 parties. Now, the reason for that is because there's no concurrent conflict of interest. Why is that? Well, because the bank, the buyer, and the seller their interests are aligned. So for a closing attorney in a normal, non-wholesale, just a normal bank transaction, the closing attorney can represent the buyer because what you're promising the buyer is that before you give the buyer's funds away to the seller, that you will assure that the buyer has good title in their name, good clear title with no liens. You can represent the seller at the same time because what you're promising the seller is that you will hold the deed they give you in escrow, just like you're holding the buyer's funds in escrow, until that deed is recorded. When the deed is recorded, you're promising the seller you will not record that deed until you also possess the buyer's money and the bank's money, as the case may be, in your trust account. So you're telling buyer and seller, I have all the money and I have the deed, and I'm holding them. and I will only record the deed when I know I have the money, so I know I can give it to the seller. Nothing can stop the seller from getting it. And I will not give that money to the seller until the deed has been recorded, so now the buyer's the owner. And then you can represent the bank, because the closing attorney's duty to the bank is to assure them that they have a perfected lien on the first lien position with no liens ahead of them. And that, much like the seller, you will not disperse their money until the deed is in their buyer's name. So real estate is an anomaly in North Carolina as far as an attorney being able to represent multiple parties. But you could only do it when there's no concurrent conflict of interest. So in assessing whether there is a conflict of interest, the lawyer must consider where there's any obstacle to the lawyer representation of both parties. So the lawyer has a duty to ensure that they can comply with Rule 1.7, which says there's no concurrent conflict of interest prior to accepting the joint representation from the buyer and seller. When contemplating joint representation, a lawyer must consider whether the interest of the parties will be adequately protected if they are permitted to give their informed consent to the representation, and whether an independent lawyer would advise the parties to consent to the conflict of interest. Representation is prohibited if the lawyer cannot reasonably conclude that he will be able to provide competent and diligent representation to all parties. Now, you see what they're doing here. What they like to do is they don't like to tell lawyers you can or cannot do this. What they like to do is say, well, you can do this, but you have to meet all of these requirements. And then they list the requirements out to where in some of the cases, at least, there's no way you can do them all. So it just becomes impossible. There's so many restrictions, and you say, I can only do it if this and this and this and this. And then at the end of the day, you're like, well, there's no way I can do that. Well, and then the bar's like, yeah, that's what we meant. And then you're like, well, why don't you just say no to begin with? You know, I don't know. It's just the way they do things. So maybe it's because lawyers don't like to be told what to do. I don't know. Okay, so they go on to provide competent and diligent representation to the end buyer. And now back to our wholesaling scenario there. The lawyer would need to tell the end buyer all material facts known to lawyer about the transactions and advise the end buyer with respect to all the facts and circumstances concerning the transaction. So then they go on to specify what you would need to tell your end buyer. First of all, that B does not own the property. Okay, that's easy enough. And most wholesalers disclose that. And by the way, what you're going to see a lot as we go through here is that we just, like I said, finished teaching that wholesale class. And we were teaching that class while these rules were being implemented. And, you know, I'm really happy to say that everything we taught, nothing was in violation of these rules, because that's the way we've been doing it anyway. So really, these rules are meant to weed out wholesalers who are being deceptive. Unfortunately, whenever, you know, a quasi-governmental organization makes rules like that, which have a good intent, it seems like it's hard to do it without at least some of the good ones getting caught in the crossfire, you know, and that's unfortunate. It's unfortunate that there's the unethical wholesalers out there that are doing transaction, which even require someone to want to regulate it like this. And then it's unfortunate that they never do it perfectly, so that ultimately, you know, some good ones get restricted from doing things as well. But that's what we have. So, all right. So first of all, that B doesn't own the property. Well, you know, if you're an ethical wholesaler, you're already disclosing that. If you're not disclosing that, you should really get some training and revamp your business practices. Then the second part of this is really putting the burden on the attorney. And this is one reason attorneys won't do these now. Whether the contract entered into between B and C, so investor and end buyer, for the sale of the property is valid. Okay, well, when the bar puts an onus like that on an attorney, I just tell you, attorneys don't want to take that liability. You know, they don't want their opinion to be relied on for something like that, because indeed, is the contract valid? Is a contract valid if you are a wholesaler and you have a property under contract from a seller, but you have not closed yet, and then you get that same property under contract to your buyer, is it valid because you don't own it? Well, what are the things a lawyer would look at to make that determination? They would look at your contract. So I would suggest to you that if you want to keep in line with this particular way of doing a transaction and have your lawyer be able to do it, in your contract to your end buyer, I would insert provisions saying that you don't own it, that you will acquire it on the day of closing, and eh, and then just disclose everything in order to make that contract valid, because the question of whether or not it's valid really hinges on, can you contract to sell a property that you don't own yet? And I would suggest to you that if your contract discloses that you will own it as of the date of closing, that would bring that contract into the realm of legality. Okay, so, and then the second part, that remember, we're using our end buyer's money to fund the purchase. So you also would have to disclose that the end buyer's money will be used by the wholesaler to purchase the property from the seller. And you have to get the end buyer's informed consent about that. Again, that's something we've always done, and the way we've done it, I'll go into later, because it actually, there's another opinion on that in here. Okay, and then the lawyer also has to disclose the price at which the wholesaler is purchasing the property from the seller, which is a fact that may not otherwise be known by the end buyers and might bear upon the true market value of the property, and or whether the end buyer would consider it in their best interest to proceed. So basically, in our scenario here, you would have to tell, Mr. End buyer, that you're buying this property from Mr. Wholesaler, and he doesn't own it yet. He will own it before you buy it, and that he's buying this for $80,000, and you're buying it from him for $100,000, and you need to understand that and decide whether that is in line with the true market value and your best interest. Now, having said that, there are a lot of scenarios in where people tell this all the time. Again, I know a lot of rehabbers. I know a lot of them are actually on this call, who just will buy from a wholesaler and are completely fine with all of that. Yeah, I mean, I just did one. I paid the guy $15,000 because it was a really good deal for me, and because I don't have time to go out and look for properties. I mean, I'm running a law firm. I'm running this group. I have another side business. I rehab plus my rehabbing business. So I don't like talking to sellers. I don't like negotiating deals. I don't like trying to jack people down on their prices. But you know what? There are people out there who are very good at that. And I am more than willing to pay them money to do that. I'm more than willing to pay them a fair fee. They've done work, they deserve it. So in that scenario, there's no problem with this here. But we do see deals where, for one reason or another, the wholesaler does not want either the seller or the end buyer, sometimes both, to know what they're making. And sometimes, I've seen a wholesaler who just ran upon a great deal, and he was going to make $50,000, and he didn't want to disclose it. So those are the ones we're talking about. So certain of these facts will be confidential, which the lawyer's going to know, because the lawyer knows all the contracts. And then certain of these, the wholesaler may not want the end buyer to know, or they may involve the disclosure, which would harm the wholesaler's interest. I guess what they probably mean by that is it's possible that your end buyer, if it weren't, a rehabber experiencing these transactions, if we're someone who didn't know, I might go, well, crap, man, I'm just going to go buy from the seller, so that could harm B's interest. So the lawyer has to consider all this in making that decision. Can I provide competent and diligent representation to the wholesaler and the buyer? So in the scenario I just talked about, if I'm the lawyer and my friend Leslie is the buyer because she's a rehabber, and my friend Jackie's the seller, all day long, I can tell them that, because they are all not going to care. Jackie's going to be like, yeah, I don't care. um, uh, you know, Leslie's buying my property and she's gonna, sorry, I missed a party in there. If Jackie's my wholesaler and, Derek Cox is my seller, Derek's going to say, yeah, I don't care. Jackie's offering me what I want for it. I don't care if she's going to make money on it. And Leslie's going to say, I don't care. It's a good deal for me. My numbers work. I know Jackie's going to make the money. She did the work. I'm fine. So that kind of transaction, no problem. But it's those ones where there's reasons that the wholesaler doesn't want disclosure that you could no longer do. In fact, that your attorney can no longer close on the same day. So the lawyer cannot represent the end buyer unless the wholesaler consents to the disclosure to the end buyer of all the facts regarding the A to B transaction. And there you have it. Now, another condition is that not only does the lawyer have to obtain the client informed consent of all the clients, but that informed consent is defined as the agreement by a person to a proposed course of conduct after the lawyer has communicated adequate information and explanation appropriate to the circumstances. And so in order to do that, the lawyer must make reasonable efforts to ensure that, it says the client or other person, but I'm just going to say all the parties in this transaction adequately possess enough information to make an informed decision. Ordinarily, this will require communication that includes a disclosure of the facts and circumstances giving rise to the situation and any explanation reasonably necessary to inform the client or other person, all parties, of the material advantages and disadvantages of the proposed course of conduct. So you see what they've done here? We just took a situation where we reasonably could have given, we could inform them, but now they've added this extra layer. And they're really saying here that a lawyer has to have a discussion with the client of, is it in your best interest? So what they're saying is, I have to say, Leslie, Jackie's buying this property for 80,000 and she's selling it to you for 100. And I mean, do you really think that's a good idea? Is that your best interest? And then you have to discuss their options and alternatives. So does that mean a lawyer suggest that Leslie go around Jackie and go to Derek and try to make a deal? I just don't know. It really puts your lawyer in a really, really difficult situation because there's a lot of big ambiguity here that takes, you can make judgment calls on, but they're saying you have to discuss their others options and alternatives. Well, yeah, you could go find a cheaper property. You could really buy this for $80,000 if you went direct to the seller. You could go back to Jackie and you could try to say, Jackie, you ain't making $20,000 for doing nothing. I'm gonna pay you $5,000. It says to me that a lawyer would have to explore all those options. And that's just, no lawyer's going to do that because, if you're saying all that if I'm the lawyer and I'm telling all that to Leslie, Jackie's going to be like, dude, I'm not bringing my closings to you anymore. Like you're screwing me. So they're, like I say, they're making these rules that they make sound reasonable, but with every new thing you read, you see that it becomes more and more difficult for the attorney to really be able to do this. So the lawyer would need to obtain informed consent from both B and C. And to do that, they must explain to both of them how the interests of both of them may be in conflict, including the disclosure of all facts and circumstances. How many times they're going to say that? So then now I have to say, Jackie and Leslie, I can represent both of you. But again, man, it may be that Jackie's getting over on you for this 20,000. I mean, I have to have that discussion with both of them. And I just, no lawyer's going to do that. Unless it is this, I mean, even in this situation where we have experienced investors, I'm not gonna go have these conversations and recommend alternate courses of action because if I do, now I have a problem representing Jackie because I've just sort of betrayed her. So they're basically giving lawyers just enough rope to hang themselves. Like, yeah, you can do this, but you're kind of screwed if you do and screwed if you don't. So with respect to the end buyer, the facts and circumstances would need to tell them to get informed consent, include but are not limited to all the matters we just discussed. for required communications to C. To obtain that informed consent to your end buyer, must also discuss, see here again, they're going to add something else, the advantages and disadvantages of the proposed transaction for the end buyer, his options and alternatives, including the fact that, yeah, you know what, end buyer, you're probably better off with a separate lawyer because I can't really tell you all this stuff. So if the lawyer cannot discuss all of these matters and then tell C, by the way, you should really get your own lawyer for this, including your wholesaler not wanting certain information to be disclosed, then the lawyer cannot obtain informed consent from the end buyer. And really, after all that, how can you really get informed consent from your end buyer with all those restrictions? So, why didn't they just write no? No, you can't do it. But instead, like I say, they say, well, you can do it, but only if blah, blah, and then if blah, blah, and then if, oh, blah, it's impossible. So the answer to inquiry 1 is basically no, except in probably some very unusual circumstances. And even then, I think it's really not possible. But again, this only relates to transactions closing on the same day where you're using the end buyer's money. And I say only those, but that is a large majority of wholesale deals. And when they first put these regulations out and I started reading them, I'm like, yeah, if I can give all the details and get informed consent, I can do that because I have a lot of those transactions where everyone knows what's going on. But the more you read, the more you just really can't, because even if you give all the details, you're still on this damned if you do, damned if you don't thing where you have to basically recommend to your end buyer that this might not be a good deal. And no lawyer can do that while they're representing the wholesaler and the end buyer. They just can't because you're not representing one of their other interests adequately. So.
Okay. We have a couple of comments in chat before we go on. Do we want to just go over them?
Sure. If you think that's fine with me.
Just to make sure, because I think, so Tim said that under this opinion, the bar is looking at disclosures between B and C, and it looks like you do not need to disclose to A, the original seller. That's the way I was reading it too. So
that's correct. If you remember in the facts, you do not represent A. So in this scenario, the seller has their own representation. So they've had another lawyer who drafted up their deed and did their documents. And so that, it does not, that is correct.
So the seller does not have to be informed of what ultimately C is paying, right? The seller's selling it to B. And so throughout this transaction, the seller does not need to be told now that you may be selling it to B, but on the same day, B is selling it to C for 20,000 more. That does
correct.
Not.
As far as we've gotten so far, that is correct.
Okay, then I think that leads into what Adam was saying, which is really C, which, if that was me as the investor, I should only care whether or not the deal works for me, not really what B's margins are. I agree with that.
Amen. And I mean, that's the problem with this whole thing. And that goes back to what I said. They promulgate these regulations to catch the bad seeds. And believe me, I've seen a lot of bad ones. There are deals I will not do because they're so unethical and because they won't disclose. I won't do them. And those are the ones they're going after. But again, when they cast that net, the good ones get caught in it. And that's exactly what we've just seen, to Adam's point. Yeah, it shouldn't matter. But there you have it. It does, because we have these rules.
And Carly wanted to know if it would be easier to do it the way Vina does, where she said she gets paid her fee well before closing and the buyer goes to the closing, so it's only A and B.
We'll get to that. They do have a rule to address that.
Okay. And Tamara wants to know if does this
although, sorry, before you move on, Jackie, I will say this. If you were my client and you were the end buyer, I would never allow you to pay the wholesaler before closing. So
True.
That's called an assignment, and we are going to get to that. But my opinion on that, if you are my client and you are the end buyer and you are buying from a wholesaler, and let's say it's all disclosed and above board, and they want you to pay, let's say it's $10,000 before closing, Hell no, because now what happens if we get to the closing table and for some reason the seller breaches the contract? You've paid them $10,000. When I do closings with the wholesaler involved, if it's an assignment fee, that gets paid at closing, never before. The only way you can assure that you are going to be able to purchase that property is to get to closing. If you've paid your wholesale fee before you get to closing, what are you going to do if the seller changes their mind?
A good point. Tamara wants to know, does this apply if it's a double close transaction?
That is what we just described as a double close. That is a
It's-
double close.
It's the same day, it's two closing on the same day.
That is a double close. That's the whole thing that we've just been talking about, was a double close on the same day.
And then Jonathan wants to know if this applies to transactions for properties that are not single family homes. Does it also apply if?
Yes, this is not like, so that's a good question, because there are many, like lending regulations, like the SAFE Act and some federal regulations that only apply to residential. And so if you are buying investment properties, they don't apply. That is absolutely not the case here. It applies to any property.
Okay.
Sorry,
Any closing being done by an attorney. Remember, this is all, an attorney can only do closings under these circumstances.
sorry, can I interject about the double close? Because I was under the assumption that the double close was but the seller B brings their own transactions to cover the funds for
Okay.
seller A.
So that's not a double close. A double close is any transactions where you do two closings. Now, like I said at the beginning, if you go back to the premise of these rules, the very first slide that we looked at, they only apply for a double close on the same day where B is not bringing their own money. So it's still a double close. It's a double close whether or not B brings their own money. Anytime you have a closing from A to B and then B to C, that's a double close. Now, your double close can be using C's money to fund B's purchase, or B can bring their own money. If B's bringing their own money, these do not apply. This only applies to where you're using C's money so far, okay?
Okay.
But that's the differences in the funding, not in the fact that it's a double close. Okay, so that brings us to inquiry 2. If the answer to inquiry 1 is the answer to inquiry 1 different if the lawyer maintains that lawyer only represents B in the A to B transaction, which you do because A already has their own attorney, and only represents C in the B to C transaction. Now here you're going to see where the bar knows how attorneys' minds work, because that's what the first thing I would do, right? Okay, well, I'm not going to represent Amy. I'm going to do two closings. In the first closing, I'm going to represent B as the buyer from A. And in the second closing, I'm not going to represent B as the seller. I'm only going to represent C. Well, good thought, lawyer, but no cigar. A concurrent conflict of interest exists if the representation of a client may be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or by a personal interest of the lawyer. The above identified conflicts would still exist even if lawyer only represented B with respect from the wholesaler's closing from the seller, and then only represented the end buyer and didn't represent the wholesaler in the second closing. So the answer is still no. And at least they're a little more direct that time, because basically your wholesaler would be another client. Or even if you said, all right, I've closed your transaction from your seller, now I don't represent you anymore, then there's still a former client. So whatever, it all applies. You can't get around it that way. Nice try. Okay, then we have inquiry 3. If lawyer concludes that he cannot represent the end buyer, can the lawyer proceed with the closings representing only B? Whoa, you're thinking, well, hell yeah, right? I mean, of course. Well, let's see what they have to say about that. It depends. If y'all remember all the times that I used to give legal minutes at the front of the room at Treia meetings, what did I tell you? The answer for a lawyer is always, it depends. So here we go. to the extent that your end buyer consulted with the lawyer or gave the lawyer any information to close the transaction from the wholesaler to them, but didn't form an attorney-client relationship, C would be, the end buyer would be a prospective client under the rule. And if an attorney-client relationship was formed between end buyer but was terminated, then they're a former client. So the lawyer is prohibited from revealing any information learned from the end buyer and using that information in any way. If this prohibition materially limits the representation, then they cannot represent B under the rules. Moreover, this is a non-consentable conflict of interest if the lawyer would not be able to provide competent and diligent representation to their wholesaler client as required by the rules, with the representation materially limited by their prohibition against revealing or using what they got from C. Well, think about it. Whenever you do a closing of any kind, right, wholesale or not, the first thing your closing attorney does is send out, buyer and seller information sheets. They really need information from both parties to close the transaction. So for a closing attorney to say, I'm closing this transaction with the end buyer, but I'm not representing them, I mean, that's just, there's no way. An attorney's just not going to do that. Additionally, the lawyer may not represent a client with interests materially adverse to the end buyer in the same or related matter if they received information from the end buyer that could either be significantly harmful to them or is material to the matter. Certain disclosures need to be made to the end buyer to obtain informed consent, as discussed above. If a lawyer is prohibited from making those disclosures to obtain informed consent, then the lawyer can't represent B. So there you go. See how they hem us in there? What's the long and short on that one? Because that one's a little complicated. If I say I can't represent the end buyer, can I just proceed with the closings only representing B? Well, I mean, I could tell you the answer to that without going through this long rigmarole. A closing attorney has to represent the buyer. I don't know how you can do a closing without representing the buyer. If you're just representing the middleman, you need to have another closing attorney, basically. And that's actually at the end, if y'all want, we can talk about some creative ways around those, because there are some, there are ways to get around these. And one of them that we've been doing is just simply hiring another lawyers will cooperate with each other and just say, hey, I have this wholesale closing. Will you represent my seller? And then, that sort of takes care of the matter. And I don't know, it may add a little bit of money to one of the parties because you're bringing in another lawyer. That's another problem with sometimes these regulations that are meant to protect people. Sometimes what they end up doing is costing the public more money. So, but that's sort of the way around that. So inquiry 4, can the lawyer use the funds provided by the end buyer for the end buyer's purchase from B to fund B's purchase from A? So this is part of the first inquiry as well, but here they're addressing it just as a separate question. So now, even if we've solved those other problems, can we do that? And I will tell you that this is the way my office has done these closings for many years to keep it legal, and everything's disclosed because the way we do it is, so you have B owes A $80,000, C owes B $100,000. So we create a loan from the end buyer to the wholesaler, and it's a promissory note and a deed of trust, and it's disclosed on the HUD. So it's like C is acting like the end buyer is acting like the wholesaler's bank. They are loaning them I said 100. They're loaning them $80,000. So we create a promissory note from wholesaler to end buyer for $80,000. Then wholesaler goes into their closing with seller. They sign loan documents just like they're getting a loan anywhere, and so they're getting funding instead of from the bank. They're getting it from their end buyer, and that's how they purchase the property with the seller. The end buyer has already wired their funds in advance. They understand and have consented to the fact that the wholesaler is using their funds to make the purchase from A. So the purchase from wholesaler to seller is completed with a loan. 10 minutes later, we sit down with the wholesaler and their end buyer. At that closing, The transaction logs show that we take the promissory note. The wholesaler is now in possession of, the property because they've just bought it. And the end buyer has already wired $100,000. So now we take the $100,000, we satisfy the loan from the end buyer to the wholesaler. And then after we pay off the loan, there's $20,000 left. That goes to the wholesaler. So that's the way we've been doing for many years. Again, a complete disclosure. It's on both HUDs, and the end buyer always knows their money's been being used by the wholesaler to purchase. Doesn't really matter if the seller knows where the money comes from. All they know is that the wholesaler is getting a loan to buy the property from them. So let's see what the bar has to say. No, not without the end buyer's knowledge and informed consent and some appropriate legal arrangement, i.e. promissory note. Without the end buyer's knowledge and informed consent and an appropriate legal arrangement, the use of the end buyer's money for the benefit of the wholesaler is a misappropriation of the end buyer's funds in violation of the rules. So again, the way we've been doing it is acceptable, but to the extent that others have been out there doing it without documenting it and without full disclosure, that's not acceptable. The lawyer cannot disperse funds from a residential real estate transaction until the deed is recorded. And the deed cannot be recorded in reverse order. So in other words, the people who aren't using promissory notes and such, sometimes they would do the transactions in reverse order. You can't record your deed from your end buyer into your end buyer from your wholesaler before the wholesaler owns it. I can't imagine anyone was doing that. That's crazy. That would create a problem in your chain of title down the road when someone looked at that title and saw that's not legal title. So I don't know why anyone would have tried to do that. I'm guessing they must have, since the bar addressed it, but that's just crazy. Crazy. I don't know. But anyway, the bottom line here is you can't record a deed until you're in possession of the funds. If you're doing it backwards and using funds to fund the deal without creating the promissory note and loan, you can't do it. I mean, it's a long, complicated answer, but actually the premise is pretty simple. So inquiry 5, can a lawyer represent the wholesaler and the end buyer in developing a legal arrangement under which the wholesaler would become entitled to the possession and use of the end buyer's funds prior to recordation of the deed from wholesaler to end buyer? And can lawyer draft the documentation for that arrangement? Now, that's exactly what I just told you we've been doing. So again, the first time I read these regulations, I'm reading along and I'm good. I've not done anything different. So far, so good. This is exactly how I've done it. And I'm feeling pretty good about things, Then we come to inquiry 5. No, no. Such joint representation involves a non-consentable contract of interest. So I can no longer, that transaction, though, as perfectly legitimate and legal as I feel it to be, everything is disclosed. We create a loan just like we would do for any loan. I can't represent them both. Now I can still do that, but I can't represent them both. So the making of the appropriate arrangement between wholesaler and end buyer, under which the wholesaler would gain entitlement of the possession and use of the end buyer's funds, which that's a lot of words to say, create a promissory note and let the wholesaler borrow funds. Prior to the recording of that deed and the drafting of those documents presents another conflict of interest because the terms of this arrangement must be negotiated. See, I just love the way they get to these conclusions. Because these terms must be negotiated between B and C. So that's a negotiation. The lawyer cannot jointly represent or draft because that's a conflict of interest if they're negotiating. So what they're really saying is that, there are terms here. Well, is that note going to be, is there going to be interest on it? Is it going to owe back more? Which is utterly ridiculous because in all the years I've done these, we've never negotiated terms. We just basically said, I'm going to borrow the money from you and pay it back 10 minutes later. And the end buyer's like, yeah, I'm good with that. Because who needs to negotiate terms when it's that simple? But what the bar is imposing here upon lawyers is that, nope, that's a negotiated transaction. It's a non-consentable conflict of interest. And by the way, we're not going to go into this tonight because it's not a matter for this class, but as this opinion notes, commercial transactions already don't allow an attorney to represent all three parties as residential um, closings do. And it's for this same sort of reason that the bar believes that because in a commercial transaction, there's more inherent conflicts in the negotiation. So it's not simply a matter of by the time a buyer and seller get to you, their contract's already negotiated. And so you can represent all three parties like I talked about at the beginning. That commercial transactions generally represent ongoing negotiations with contract terms, and they're often not finally negotiated. So it's always the case in commercial transactions. So they're sort of comparing it to that. And they're saying that joint representation is only available in residential real estate transactions because the contract to purchase is entered into prior to commencement of the representation. Well, with commercial deals, that's often not the case. But and I really don't know how they're making that leap to compare them. But what they're basically saying here is that because, so the contract may already be entered into by the time it gets to you. So that's fine for the lawyer. But now, as you're proceeding to closing, you have this negotiation for the terms of the promissory note and the loan, which again is it's just crazy because that thing's never negotiated. But technically, legally, yeah, you can't do it because of that. I mean, I believe they really stretched. But so again, the way we've been solving these is just bringing in another attorney, and you can still do the promissory note and deed of trust. You can still make sure everything's disclosed, but there has to be another attorney involved because, they're going to have to look over that promissory note and deed of trust and agree to the terms. It's utterly ridiculous, but that's where we are.
So Kathie, just a question.
Mhm.
So if you're a B, a wholesaler, in lieu of using C's funds, if you did reach out and get transactional funding, so from, we've got Oakwood, we've got people in Treia. So if you're not using C's funds, if you're actually borrowing the money from a lender for one day, that removes that requirement of the promissory note for C. Is that correct?
Yep.
Doesn't solve for, you still need to have another attorney for C.
Right.
If it's the same day, but
you're no longer negotiating the terms of that promissory note. So that is correct.
Okay. So
again, these scenarios are only apply to situations where you are using the end buyer's funds. As far as I can tell from being over these new regulations, they do not affect any transaction in which you, as a wholesaler, either bring your own money and buy it and then sell it, or in which you borrow money from an outside source, not a related party to the transaction. As far as I can tell so far, none of that even is addressed by this. So if that's what you're doing, no problem. Okay, then just in case they have missed anything that you might think of to get around this, in case you come up with any other creative ideas as a way to help your clients get their daggum deals done, they're going to give us a little catch-all here. Are there other concerns about lawyers' participation in the closing of these transactions? Good God, what are they going to throw on us now? Yes, of course there are. There are other issues the lawyer will have to consider before determining whether lawyer can proceed. Such issues may include the following: whether lawyer would be assisting an other person engaging in a criminal offense or would be engaging in context constituting a criminal offense. What the what? Like what? Did you not scare us enough? Now you need to say we might be helping someone commit a crime. Why? Because I don't know. I guess goes back to the fact that if you weren't documenting it with the promissory note, maybe that could be considered, I wouldn't say stealing the funds because you're paying them back, but maybe conversion of the funds. I guess that's what they're getting at. Like if you're letting the wholesaler used the end buyer's funds that have been put in your trust account for their purchase, that's really an illegal use of their funds. If you haven't, drafted a promissory note, I just, that's crazy. And then whether lawyer would be engaging in conduct involving dishonesty, fraud, deceit, or misrepresentation, such as in the identification of the owner and the preliminary opinion of title. Okay, that's valid. So some lawyers have, when they got their title, they have put on title that the wholesaler owns it. That's not cool. You don't do that. There are legitimate ways to get around that. You just don't finish that part up until the deal's done. So yeah, that's a big no-no. All documentation prepared by the lawyer must be accurate, including identifying the record owner and any preliminary opinion of title. So in other words, when you submit your title to the title company, you cannot say that the wholesaler owns it, because they don't. And that's just common sense. That should never be done. But I will say, I thought this was in here somewhere, and maybe it is, maybe I just haven't gotten to it yet. But there were also, attorneys in the past who would prepare what they call blind HUDs. And that's been a no-no for many years. That should never have been going on. But basically, that's to conceal, from all parties what was going on with the other transaction. I think that might be, I'll wait, because I think that might be addressed here later. So inquiry 7, if all conflicts, confidentiality, and funding issues are properly resolved, the transactions are permitted by law, and no other issues exist. Well, good Lord, whoever is going to fall under this? Because after everything we just went through, I can't think of a closing that would meet all those requirements. No other issues exist that would preclude lawyer from proceeding with closing these transactions. What accountings must the lawyer do for these closings? And to whom must the accountings be provided? I think this might be where we get to the issue of the HUDs. Okay, so here we go. Accountings are due to A, B, and C, to the seller, the wholesaler, and the end buyer. So remember, at the beginning of this transaction, we're closing the transaction from the seller to the wholesaler, even though the seller has their own attorney. We're still doing that closing. And then we're turning around and closing again from the wholesaler to the end buyer. So from the first transaction where the wholesaler buys from the seller, we have to do a trust account ledger, and we have to do a written accounting of receipts and disbursements for everything, all monies that flow through the trust account. And this says, or to which B becomes entitled to possess and use. So in other words, if there's a promissory note, we disclose that. Okay, that's no problem. The written accounting must be provided to the wholesaler, and the client ledger must show the receipt of the funds. So that would be the quote unquote loan funds, including identification of funds provided from B's use by C and the disbursement of those funds. I've seen no problem with that. I mean, if you're doing that seller to wholesaler transaction, and if you have promissory notes which have been drafted by you or another attorney or negotiated between the two of you, those are just common disclosures. You're going to disclose all that anyway, so that's fine. From the B2C transaction, from the wholesaler to the end buyer, the trust account ledger must provide a written account of receipts and disbursements. The settlement statement must show everything provided by C or on behalf of C. So again, you're going to show that that loan was made to the from the end buyer to the wholesaler, and then you're going to show it being paid off. And the written accounting has to be provided to the end buyer. This is basically just saying, so they have to know you used their funds, which is fine. I mean, you shouldn't be doing it if they didn't know. And then it has to show the receipt of, in other words, it has to show when C, the end buyer, paid their funds into you, and then you loaned them to B, and then you paid them back. That's what that would show. And they have to show that it was used in the A to B transaction. And again, that's just the way we've been doing them forever. Just now, there has to be another attorney involved. Then for both transactions, each seller, so you have your original seller and then your wholesaler seller, must receive a written accounting of the proceeds to which they become the beneficial owner upon the recording. This accounting must show all disbursements made from those proceeds, including all costs and fees. Okay, so I don't, there's no problem with this. This is common sense. I don't know. Inquiry 8. Now, here's where we're getting into assignment fees. Instead of being structured as A to B and B to C. So this is a double close. And so in other words, instead of being a double close, the wholesaler enters into a contract to purchase from the seller, and he assigns his rights under that contract to C. This is, again, very commonly done. Let's use our example again. I'm the closing attorney. Tamara is the seller. Jackie's the wholesaler. Leslie's the end buyer. So Jackie, in our situation here, enters into a contract to buy Tamara's property for $80,000. Okay. And then she negotiates with Leslie to buy it for $100,000. Now, instead of having a double close where Jackie's going to buy from Tamara and then turn around and sell to Leslie, Jackie takes the simpler route, which is the one I always recommend, if possible, assign. And Jackie enters into an assignment contract with Leslie. That assignment contract is a simple one-page document. It basically says, I entered into this contract with Tamara on this date. I'm assigning it to you for $20,000. At closing, you're gonna close. You're gonna take over all my obligations on that contract, and then you're gonna pay me $20,000. So at closing, Leslie, you are gonna close directly with Tamara for $80,000 because you're just gonna assume all the terms of Jackie's contract with Tamara, and then Jackie's gonna get paid an assignment fee on that settlement statement. This goes back again to Tamara's question about paying, or I'm sorry, it wasn't whoever asked the question about paying the $20,000 in advance. I certainly have seen it done. You certainly can do it. If you're my client, you won't be doing it, because if Leslie paid Jackie $20,000 and said, okay, here's your assignment contract. Now you just go to closing with Tamara. You're going to close for $80,000. That your price all in is $100. Jackie's like, that's cool. Here's your 20. Jackie goes to closing and Tamara's like, you know what? My brother just moved back here and he really wants this property and I'm going to sell it to him instead. Okay. Besides the other problems you have with breach of contract, I mean, there's a whole bunch of issues there we're not going to get into. But the bottom line is, for whatever reason, the seller breaches that contract. Leslie just paid Jackie $20,000 and Leslie can't buy the property now. So, you're going to go back to Jackie and get your 20 back. Hopefully, yes. But, I wouldn't take that risk. I don't let my clients take that risk. So, okay, so we're going to do an assignment. So the wholesaler engages the lawyer, which is me, for the representation to close from the seller directly to Leslie, like we just talked about. So Jackie's like, Leslie, here's an assignment contract for $20,000. You're going to close right with Tamara for $80,000, and I'm out. And then expects that the lawyer will also represent the end buyer. The wholesaler does not want, important, the seller or the end buyer to know this. Okay, this is what I was looking for with the blind HUDs, about the transaction, certain information about the transaction. So we're saying, Jackie's saying, okay, Kathie, I want you to close this transaction between Leslie and Tamara, but I don't really want them to know that I'm making this $20,000. The assignment document does not disclose all information about the transaction, such as the purchase price between Tamara and Jackie, or the amount of the assignment fee that Jackie's being paid. Jackie wants the settlement. Sorry, I shouldn't quit using her name. The wholesaler wants the settlement statements prepared in a manner that will not disclose all information to the seller or the end buyer. Can the lawyer represent? I mean, I can tell you without reading the answer, no. You would never do this. This is, from a very basic obligation of an attorney is to always have full disclosure. Clearly, this is a violation of that. If you're doing an assignment, you do the assignment all on the same settlement statement. And that settlement statement is directly between Leslie and Tamara for $80,000 on that settlement statement. And you say a fee paid to your wholesaler, Jackie, and $20,000. There's no way anyone can say that's not full disclosure. Everyone can see all the terms, and no attorney should ever be doing this. And if you have ever had an attorney who has, I would question that. So this scenario presents many of the same issues. The lawyer must be able to disclose all information. and if he's unable to because of a duty of confidentiality to B, and then in addition, the lawyer must be able to be forthright with all parties and be able to disclose any information, of course. And this one, you know, I think is just much easier than the other transaction, that all your documents, closing statements, deeds must be accurate. You're going to provide accurate accounting. So basically, if you are doing, if your attorney is doing wholesale assignment fees correctly, there's absolutely no problem. As long as you disclose everything on the settlement statement, as long as the seller can see that $20,000 fee and the end buyer can see it, absolutely no problem. And pretty much with, we have one inquiry left, but if you have not surmised from what we've gotten through so far, pretty much, if you don't like the full disclosure and the extra attorney involved, what you need to do is have your own money or get bridge funds, buy the property, sell it the next day to your end buyer, you know, and suck it up and pay the fee for the bridge money funds. If you just don't want, for one reason or the other, let's say you do stumble upon that deal that there's really a rare wholesale deal and you can really make 50,000. I've seen it happen. It's not common, but it's rare, but it happens. And the seller's happy with what they're getting, and the buyer's still getting a decent deal, and you can make 50,000. You know, those deals don't roll along very often. I mean, but let's say you happen to stumble on one. You might not want the parties knowing. Well, you know what? If you're making $50,000, you can damn sure afford to get some bridge money. So I would suggest you just do it. One or the other. You're either going to give full disclosure or you're going to just buy that property. Once you buy it with your own funds, you go sell it however you want. Nobody cares. All right, inquiry 9, could lawyer represent A, B, and C in these transactions? The same issues apply if lawyer wishes to engage in the multiple representation of A, B, and C. See opinions 1 through 8. Yeah, that last answer is really a cop out. I mean, like, but so here's the bottom line. If everything is disclosed to all parties and you are doing an assignment, you're fine with that attorney. You're going to need another attorney in there. You're always going to need 2 attorneys now. You're always going to need full disclosure. That's the bottom line. And if you don't have multiple attorneys, actually 2 for an assignment and probably 3 for the simultaneous, the double close on the same day, because in that case, the seller already had their own attorney. So you really have 3, 2 for assignments. If you are willing to have an extra attorney and have all the terms disclosed, you're going to be fine doing wholesale deals. If you're trying to hide from either the buyer or your seller or both, then you need to get separate funds. Do not use your seller's funds and buy the property and then sell it. If you are going to use your buyer's funds to fund your transaction with the seller, you can do that, although they've tried really hard in here to stop you from doing it. But, you know, if you have 2 attorneys who are willing to do it, to draft the documents and to represent the various parties, and everything's disclosed to everyone, you can still do it. They've made it a little harder, but as always, there are ways of getting around things. You know, but what you need to know is if you come upon an attorney, you know, who's doing this not in compliance with these laws, you need to run the other way, because that's an attorney that you're eventually going to get in trouble with. Now, on the other hand, if you run into an attorney who abides by the rules, but can help you think of creative ways to still work within them, that's okay. One such example is, let's say Jackie's our wholesaler, Tamara's our seller, and Leslie's our buyer. So Jackie sets up an LLC. We're going to call it Bud's Homes LLC. Now, Bud's Homes LLC contracts with Tamara to buy the property for $80,000. And then Jackie goes out and finds an end buyer to buy that property for $100,000. And she says to Leslie, you know, Leslie, instead of selling you this property, I'm just going to sell you an interest in my LLC. So I'm going to transfer the LLC to you, and the LLC owns the property. As long as Leslie's cool with that, we can work ways around that a little more. You're still, you know, you're still going to need the funds to buy it, and you could still ask Leslie to borrow those, and we still have the same issues about negotiating the promissory note. But you know, as long as you're willing to be honest and disclose everything, we can figure out a way to do these transactions and stay in compliance with the laws. They just don't make it easy, but we can do it. So that's the end of the new regulations. Again, as you can see, it's all on attorneys. It's not saying that you can't do anything. It's, but effectively in North Carolina, your transaction have to be closed by an attorney. So if your attorney can only close under certain conditions, that pretty much obligates you to them. You can't do it if your attorney can't do it. So, questions?
I was a little confused before because I've always been told from attorneys that you cannot do a double close
Kathleen,
transaction
you have to, so
without.
you have to balance yourself. All right. So
Oh.
you see how when you're balancing yourself,
Okay, let's one at a
pedal.
time, please. If you don't have the floor, please mute yourself.
Oh,
Sorry, go
sorry.
ahead.
Yeah, I was always under the assumption, and I've talked to several different attorneys, and they will not double close without bringing their own transaction funds. They won't do it. I maybe found one attorney that will do it, so I thought it was illegal in the state of North Carolina. But you're saying that you can use seize money to double close on transaction instead of doing an assignment.
You can, under those very strict conditions that you just saw.
Oh, interesting. Because I know tons of attorneys that are like, no, you have to bring your own
So let
money.
me tell you something about closing attorneys. There are very few closing attorneys who are investor savvy. If you are an investor who's regularly doing deals, you need to find an attorney who understands investors and creative deals. And I sort of look at it this way. I was actually an investor before I went to law school. So as an investor, it's very easy to become a closing attorney. I mean, you become a closing attorney, you learn property law in law school. A closing attorney is very forms, is a normal closing attorney who doesn't represent investors, essentially is a document pusher. You know, there's title work and all that stuff, but then it's all very forms driven process. Sign here, sign here, sign here. It's very standardized forms driven process. For an attorney doing that, to make the leap to understand investors is actually quite difficult. As a matter of fact, I usually tell people that it'd be easier for a litigation attorney probably to become an investor savvy attorney, because litigation attorneys are used to sort of skirting the gray areas and figuring out creative solutions. Real estate attorneys are not. Real estate attorneys don't do creative shit. They're forms driven. If you are an investor first and become an attorney, that's easy. It's easy to become an investor and learn to wear the attorney hat. For an attorney who is a real estate attorney and standard forms driven attorney, to learn to wear the investor hat is very, very difficult. So the first thing you need to do, and that's a really good example of what your Treia is invaluable, is because you can ask and say, hey, who's a good attorney who's investor savvy? And for sure, attorneys who won't, do well prior to these rules, attorneys who would not allow the use of the end buyer's fund, they just simply then figure out how to be creative to do it, because you can't do it ethically or legally if you're not telling anyone. But you know, when that came down to me years ago, when I developed the way of doing it, it was like, okay, well, you want to use your end buyer's money. Well, you can't use it without telling them, and you can't use it without disclosing to everyone. So how about this? We're going to actually make them make you a loan. You know, I made that up, and I was pretty proud of it. Now, obviously, I read something once that said, any idea you have, ever how unique you think it is, this is probably another million people somewhere in the world who came up with it. So, you know, it's sort of proving the point here. Here it turns up in the opinion, and here I thought, you know, what I was doing was my own method that I was completely sure of, because I solved the problem. So, all right, the problem is the wholesaler needs funds. The end buyer has funds. The wholesaler wants to use them. The problem is we can't do that without disclosing it. How do we do that? Well, we document it, and the world knows. We make a promissory note. We make a deed of trust. we tell the end buyer we're using their money. Not only we're using it, we are borrowing it from them. It's official. It's disclosed. It's on the settlement statement. The seller sees it. So, you know, it's something I've been proud of for years. And here it is in this opinion, like, well, obviously a million other people had my idea too. So, but the bottom line is, as a real estate investor, you need an attorney who is willing to be creative while keeping you within the bounds of the law. It's kind of the same with accountants and attorneys. There are those who feel that their job is to keep you way over on this side of the law and walk a straight and narrow line. And then there are those who are willing to be creative and let you walk that fence and help you walk that fence, but never ever let you fall over to the side of, you know, erring of being outside of the law. And that is very important to an investor and finding an attorney to partner with. So
Thank you.
I've got a quick question. So I just wanted to confirm a few details because, you know, before this workshop, I had heard probably about a month and a half ago, maybe two, about this coming through the pipeline. So it's like slowly starting to make its way through North Carolina. So very appreciative of this workshop. My understanding from the very beginning, since Harry Marsh kind of took a very big stance on this, was that this applies to all double closings, no matter whose funds you're using, whether your own hard money or funds from the end buyer. This applies to all double closes. You would need to have two separate attorneys handle a double close, despite where the funds are coming from. You're saying, and I just want to kind of get some clarity. You're saying that that's not necessarily true, that that as long as you're bringing your own funds for the A to B, that you can use the same attorney from the B to C and they're not obligated to all of those disclosures. Is that right, Kathie?
I mean, that's a great question, honestly, and I would have to think about it. I would go back to the beginning here, and I will say that the facts apply to an ABC transaction where we're using C's funds. I mean, that's pretty specific. Now, having said that, can I go through some of these things we talked about and find things that might be a problem for an attorney, even if they were independent funds? And what I would have to do, and I have thought about this a little bit, but very not enough. And I have had some conversations with Harry Marsh about it, actually. And Harry is, a really investor savvy closing attorney in the Charlotte area, who has really, come out strongly against this and sort of been fighting the bar on it. My way is more to usually try to find a way to work within it, but I have a great deal of respect for Harry. So what I would have to do is I would have to go through all this again and think through that, all these things they say I have to think about. And I would have to apply those in the context if I have a completely separate funding transaction. So obviously, all this is still going to be disclosed, no problem. But I think probably the most concerning thing would be that part. Is my disclosures materially limited to another client? Well, I don't know. If the wholesaler has bought the property using their own funds, and they bought it for $80,000, and I did that closing, and then now I'm going to go do the closing where they're selling it to the end buyer. Does that really make a difference? So I still have to give count. I think the one that would give me the most pause is that thing where I have to give counsel about what I know, right? Because I still know that wholesaler bought it for $80,000. But, and I probably know if they're selling it the same day that they didn't go in and do any sort of $20,000 worth of work to it. So that would certainly give me pause. In my opinion, and it's what I've talked to Harry about, I would, in most wholesale circumstances now, in fact, Harry and I even have agreement to bring each other in that, I would bring him in as the other attorney. I think to be safe for wholesale closings now, that involve a double close, I am going to involve another attorney probably no matter what.
Okay. My follow-up question to that was, I keep hearing like this really mainly only applies to same day closings or what have you. But what if I was closing on the property today for the A to B and then selling it to the end buyer next week, but we're still using you as a closing attorney, even if we're not closing on the same day, you've still been contracted or geez, the word is not coming to me. You have been yeah,
Contract is okay.
contracted. Yeah.
Yeah.
You have been hired by the end buyer. Still for the same transaction, even if it's not closing on the same day, you still are privy to all the information of the A to B, even if we're not closing until 2 weeks later or a week later.
That's
Am
right.
I still
And
right
here's-
in my
here's-
assumption that, I'm sorry.
That's a good question. And here's what I think is the difference. Remember, our fact scenario is very specific. So it might be easy to say, hey, ABC, same day, using C's funds. But I do think, like, as the answer to your first question, you do have to think beyond that a little bit, that if some of these analysis apply, even if there's a separate loan, you have to consider that, which is why I'm probably going to always involve another attorney now, unless it's an assignment. However, I think the difference is, if you're selling it 2 weeks later, is, in 2 weeks, as far as I know, you could have gone in there and done a complete rehab of that home, right? So I think the thing is, on the same day closing with a $20,000 difference, the attorney knows that basically all that wholesaler is doing is flipping that property. If you come back to me 2 weeks later, I don't have the duty to inquire to you what you have done. You had that property for 2 weeks. You could have easily improved it by $20,000 or whatever the amount of your wholesale fee is, right? So
Do you
so
still
I
have a
think-
duty to the end buyer to at least bring up the fact, like, hey, it's, there's a 2 week separation between the closings. Now it's very possible they went in and did some rehabs, but if they haven't done a rehab in those 2 weeks, like, you might want to reconsider whether this is in your best interest, because it almost seems to me that this person's not doing anything and they're still flipping it to you for a large profit. Like, would that still fall under your obligations as the representing the end buyer, even if it's a
So
2 week
my
later closing?
opinion on that, so there's no answer to that question. I mean, nobody knows the answer. My personal opinion would be no. I do not believe that this opinion requires me to do that. I mean, if I'm faced with a situation where I know on the same day this is happening, I have to disclose that. But now you are posing a scenario in which you are really putting the closing attorney into a position of having to make judgment calls. And I don't think the bar can do that. That would be my opinion. I mean, I would not go that far. I think that is way without of the scope of what the bar can require. I think it is way without of the scope of what I would have to disclose. If you had that house for 2 weeks, I mean, for all I know, you could have demoed that house and you're selling a lot now. I mean, anything could have happened in 2 weeks. And I don't find anything in these regulations that make me inquire into that. What I see in these regulations is the duty to disclose what I know. In 2 weeks, I don't know anything of what happened. And I think it is a real stretch.
But I guess you would know though, like, because let's just say I enter into a 4 week contract with the seller, and at week 2, I find my end buyer, and we're going to close in 2 weeks from there. Then 4 weeks later, my apologies. So there's still a 2 week overlap where you're representing the wholesaler in the A to B, and you're also representing the end buyer in the B to C. There's still kind of an
this
overlap.
This is where you're going
right?
to find your difference in attorneys who are straight and narrow, and the ones who are willing to be creative to help you. As far as I'm
Sure.
concerned, it's my duty to disclose what I know and to keep everyone ethically within the bounds of the law. If I can justify my position in a way that is reasonable, then I'm not obligated to go beyond that. So my position, and this is just my personal, there's no answer to this question. Nobody knows the answer until someday the bar, unless someday the bar decides to make another rule about it. But my opinion on that is that it is never going to be my duty to inquire what you did on that property in those 2 weeks. That's not my business. You don't have to tell me, and I don't have to ask. And anything can happen in 2 weeks. So I would consider that, geez, I'm going to tell you what, unless you're a regular client of mine, I might not remember you in 2 weeks. I've plenty of times. I do so many closings. I often don't remember. I've in fact stopped asking questions about people that because too many times I've made some just polite inquiry at the beginning of a closing only to say, well, we did a closing with you a month ago. I know I don't, I literally might not remember. So my answer to that is no, but that's a personal decision that different closing attorneys might very well make very differently.
For sure. Last question. Just want to make sure there hasn't been any changes in all of these examples that you used. I feel like you insinuated that the seller was using a third-party different attorney. Most transactions I've seen and have been a part of, just for the sake of ease, sellers use same attorney that the buyer's using to prepare their seller doc. So has there been any changes as far as sellers using same attorney as the buyer? Is there anything to be aware of if the seller is going to be using the same attorney as the buyer in the double closing?
Yeah, that's a good question. I found it odd that the facts proposed that the seller had their own attorney, because you're right. Often sellers have their own attorney, although that attorney's role is generally limited to just preparing seller documents. There's no real representation. So I don't think it makes any difference, again, as long as everything's disclosed. I mean, I feel that what we've done in closings even goes beyond some of these opinions, and that we've always disclosed everything to the seller as well. So I don't think that would make any difference.
Cool. Appreciate you, Kathie.
Yep, my pleasure. Anyone have anything else? Otherwise, we'll wrap this up.
Hey, Kathie, this is, go ahead. Go ahead.
But yeah, it's Tim. I've got, sounds like the biggest problem if you're doing with the B and C stuff is the obligation to show that you as an attorney are facilitating some kind of negotiation between B and C. That, that they say that you're supposed to look out for both of their best interests and tell both of them that they have alternatives and they should consider this and they should consider that and things of that nature. Putting aside whether I think that's ridiculous or not, maybe there is some way around that. If you could, have sort of an agreed set of facts where everybody would write down that, oh, hey, between B and C, B, you don't have to sell to C. C, you don't have to sell to B. C, you could buy for a better price. C, you could do this. B, you could do that. Everybody writes it down that, oh yeah, we discussed all this. And everybody's aware of all of these things. Realistically, in these sorts of transactions, the ultimate buyer knows that the wholesaler is making money. Just like you mentioned at the beginning of the show, the wholesaler is making money for providing a service. They're going out and finding this property, and as opposed to improving the property and adding value to it, they're the ones who picked up the deal. I'm perfectly happy to pay a wholesaler. Frankly, I don't care how much they make. As long as I make money, I'm happy.
Same.
And so, but so it's, is that a possibility? And then once you answer that, I want to try to repeat back to see if I got it through this old head.
Yes.
Of what we have
And
to
by
do.
the way, y'all, this is Tim Burrell. He's been our speaker at subgroups and is also an attorney and as well as investor. But yes, Tim.
Only in California, not here.
Yeah, only in California, but still, a lawyer's a lawyer. He can't do your closings, but he does have a legal mind.
Which is why I'm not an attorney here.
So, yes, that's one thing we are thinking about doing, is just actually even maybe beyond what you said, is just drafting up some standard disclosures that say all that. And we can do that, but I think, so no matter what we disclose, if, again, back to the facts, if we still have the situation where you're using the C funds for B's purchase, I think no matter what I put on that disclosure, I mean, if I put on that disclosure, B is using C's funds to fund the purchase, and the terms of that were negotiated in advance prior to retaining the attorney. I'm willing to walk the line for sure.
Yeah,
That
I'm a
might be a
little,
little close to the line for me.
yeah,
That might be a
I'd be
little
worried
close.
about, I'd be worried about that also. I
Yeah.
think you need to have a separate attorney
Yeah.
draw the note, draw up the deed of trust, and have them do that just to take the heat off of you.
Yeah, so I think
I don't see a way
my
around that.
answer to your question, I think, is yes, up to that point. For everything else, yes, I think you could write a standard set of disclosures that everyone agrees to, and that would keep you safe. And that's one of the things we're talking about doing. But because so many of ours do use the funds, I'm probably most cases going to be bringing in another attorney anyway. And I honestly feel that I should be able to include that as a disclosure personally as well, that they've already negotiated the terms of their promissory note. I'm just memorializing them. I feel that I should be able to do that. But because of the very specific wording of these regulations, I don't think I will do that. No matter, like you said, as ridiculous as it seems, I think I should be able to disclose that and be safe. I don't think I would risk that. That's a step too far for me.
If you'd be kind enough to let me just walk through it and see if I've got it. So A to B, you don't have a problem. You don't have to disclose anything to A. B to C, you have the issue where you need to, disclose the stuff, which frankly, the C being a sophisticated buyer should already know that the wholesaler is making money. And so if you've got that disclosed, if you can have something to make it appear that there has been a negotiation that you've been involved in between B and C over the terms of their transaction, wonderful. And if you have a separate attorney drop the note and the deed of trust for the funding from C to B, which, they're loaning them that money for a few hours and then getting it paid back. So if you do all of those things, then you can do it all in one day. You have to have at least two different attorneys, and you can walk the line and not trip over it.
That is correct. And I think actually though, there are three attorneys there because possibly under this scenario, it says A has their own attorney. And if you
exactly.
were drafting those seller documents to A, I would certainly make sure that A was informed as well. I'm a little surprised that the bar doesn't touch on that, and I've wondered why they didn't. I'm assuming perhaps they just feel that if the seller is satisfied with their purchase price, it shouldn't matter what B does to it after that. But to me, I'm surprised that they let that go. So I generally make sure the seller's informed as well.
I'm glad you reminded me of that because okay. So A has to have their own attorney for the seller documents. B and C use the same closing attorney. C is represented by an attorney who drafts the note and the deed of trust to loan the money to B. And with all of these attorneys, now frankly, now you can see the reason for the bar exam because three attorneys are getting paid where only one of them used to be paid before. So now I can see why why this is being done.
Crazy.
Yeah, thank you.
But I think you got it. You're accurate.
Yeah. So Kathie, to me, it seems a little odd, and just a comment, that the concerns all seem to be about B and C. And really, to Tim's point, B is a wholesaler, C is typically an investor. So that is the group that is most familiar with these transactions. It's A that I would think they would be more concerned about, but A's not a part of it. So
like I said, I've pondered that, and the only thing I could come up with is they just thought, oh, A's happy with their 80, so who cares what happens after that? I don't know, but that's why I say again, in our transactions, we always ask our clients if both the buyer and the seller know what they're making. So I'm surprised as well.
Hello.
Yep.
Can I ask a question about that? It's just like you just said on that last point there, where you said, you would let the seller and the buyer know. Do they know what the wholesaler was making? This is even if the wholesaler is bringing their own private funds to the table, or is this you're talking about when they're trying to use the C's funds for this closing?
Yeah, I think more so that if they're bringing their own again, or and also in an assignment, I would always make sure that the seller knows as well.
And so, and that is I guess that for me, that seems like, okay, if the like if even in an assignment, they signed an agreement that said that, this is assignable. So even if I was assigning this to, my own, like my flipping company or my buy and hold company, if I was assigning it, and why would the seller in this situation need to know that I'm going to make $20,000 off of this? Because like they said, like they did in the first one, if they were fine with 80,000, they shouldn't, it shouldn't matter if I sold it a week from now or if I sold it at the closing table
Well, I
for
mean,
20,000.
I guess
That
that's
cost.
the position that the bar has taken, but I think it's different on an assignment, because on assignment, you remember, you can't do two separate HUDs not disclosing all the facts. So I think on an assignment, they have to know. When people come to me with wholesale deals, and again, I'm going to have to make some changes, but for the most part, the way I'll do the first part remains the same. The first question I always ask is, I'd say there's really three ways that you can do this. The easiest, cheapest, and simplest is to do an assignment. You can do an assignment as long as the buyer and seller both know what you're making. And in most of the cases of my deals, that's what happens. They say, yes, we do an assignment. So on the assignment, you have one closing. It goes from your seller to your end buyer. You, as the wholesaler, are a line item on there with an assignment fee. That's quite simple. The seller can see it, the buyer can see it, and you get paid. So I say there are three ways to do them. Fastest, simplest, and cheapest is the assignment. If your buyer and seller know what you're making, by all means, do an assignment. If for some reason, you don't want to disclose everything, then you're going to have to move into a double close situation. And then in the double close, you don't have to reveal to the seller. And the bar seems to agree with that for the reasons that you just stated. However, to do a double close, you have to buy it. So you have more closing costs. So now it's a little more expensive. And, you have two closings. So there's two sets of fees, which you are only the buyer in one of them. So not that much more expensive. And then if you can borrow money from your end buyer. So now in number two, your end buyer is going to know what you're making because you're borrowing money from them. And then your seller doesn't have to know. And that's where you create the promissory note. And again, I won't change the order in which I give these options. I will simply change the fact that I'll bring in another attorney. And then I say the third option is if you don't want your buyer or your seller to know, really, if you want to borrow that money from your buyer, then you go out and get bridge funding, you buy it, and then you sell it again. So I think those three choices and the order in which I recommend them will not change. Just some things in the way I will do them will change.
And not to try and beat a dead horse in a sense, but what I'm getting toward is, it seems you're very investor friendly in that regard. But like a wholesaler, for instance, and I heard the gentleman before the last gentleman who spoke, he said, a guy who's not doing anything seemingly could walk away with $50,000, right? Whereas I feel that if you're disclosing it, right, where our paperwork already discloses that, hey, this is I can assign this agreement, this contract, right? If you disclose it, then now I don't mind that it shows on the hood. Anytime I do an assignment, of course, it's going to show on the hood. If that, I don't mind that it shows on the hood. But if it is, pointed out that, hey, this guy's getting ready to make $50,000, are you okay with that? So now we're going to have an issue getting that person to the closing table where it shouldn't have, because they signed an agreement for what they said they were going to sell it for. And that would then, it's like putting a highlighter onto it, right? There's no need to put a highlighter onto it.
Have you always in the past have your assignment fees on the HUD so the seller can see them?
Yes, I've always done it that way. And my attorney won't, when I've heard tell of this blind HUDs, my attorney would not do those things.
I wouldn't either. I mean, that's completely unethical.
But then these new Altas came out, right? But even though someone signs the Alta, they still get a HUD which has everything on it,
Right.
And so but I do, if I'm making a certain amount and I don't want to ruffle any feathers, right, then I will use my own funding to make a closing. But I guess in the regards of everything, I think sometimes it's I guess this ecosystem of investing, right? Where the wholesaler is seeing that they haven't done anything, but they probably paid, five five VAs just to
Yeah.
get this investor the deal that's gonna make them $80,000, right? So if I can make 50 and you can still make 80, I was the one giving you the opportunity. And I feel like this ecosystem needs to tighten up as far as that is what is causing the rift in every, all of these different regulations, I feel, because the ecosystem is kind of off whack where everyone's counting each other's pockets, realtors, and everyone, right?
Well, I think it's important to keep a couple things in mind. Number one, that this is, really intended to weed out the bad actors. But also, number two, don't underestimate the hand of the realtors in this. Realtors have been complaining about wholesalers and trying to say that that's illegal for many, many years. I had many clients get inquiries from the real estate commission in a wholesale deal telling them they can't do it. And you know what I used to tell them? I used to say, I don't think they'll ever file legal action on it. I think they're just rattling their sabers because a contract's assignable. How can they say it's not? Well, lo and behold, and then I used to say, but I don't want you as my client to be the one to find out, is I don't want you to spend the money to fight the real estate commission. Well, lo and behold, one of my clients was the test case that got sued by the real estate commission, and they claimed that because he was wholesaling a property, and they waited and they chose a good case because he didn't even put any money down, any earnest money. The real estate commission has always leaned on that lame excuse, if you have skin in the game, and then maybe it's okay. And they've always been kind of vague. Well, they picked his case because it was a pretty strong one. I don't think he had any earnest money, and they sued him. So we filed our answer, and the answer basically said it's an assignable contract, and that's the law. Like, he is by law allowed to assign this contract, number one. And number two, his quote unquote skin in the game, whether or not he put any money down, he is obligated to buy this property if he doesn't, whether or not he finds an end buyer. Now, whether or not that's true, or whether you've given yourself an out in the contract, is obviously not a point we would want to bring up with the real estate commission. But that was our answer. Like, you talk about skin in the game, consideration doesn't have to be money. This is an obligation. This client is obligated to buy this property whether or not he finds an end buyer. And the real estate commission dismissed their complaint and never went forward. So I still think it's legal, but I still think don't underestimate their hand in this, because they tried it the legal way and that didn't work. Maybe they'll try to get a law passed. Maybe they already have, who knows, and didn't succeed. And this is, an easy way for them to control it by getting at the attorneys. So one, bad actors, and two, realtors who don't like you as a wholesaler because they think that you're doing their job.
But that's what I was talking about with the ecosystem. It slows them down. If their favorite investor who they list that investor's flips, if I'm not wholesaling at the rate that I can wholesale at, then it's slowing the realtors down as well.
So whether or not the realtor's position make any sense, nonetheless, it is their position. I think there are plenty of good realtors out there who understand it and are okay with it. And I think what I think about realtors, with apologies to anyone who's on here, if you're on here, you're likely a good realtor, but there aren't many of them out there. I deal with a lot of realtors. It's not that hard to become one. You take a course, you get your license, you go get your glamour shots with your dog and get a business card made with it, and you're a realtor. I think that the vast majority of them do very few deals. They don't continue to educate themselves by joining groups like this, by joining education like this, by joining any education, and they don't do a lot of business, and they like to bitch and complain that someone's stealing their business. I think good realtors who work hard and who educate themselves and understand things like this don't have a problem with it. Unfortunately, there are a lot of realtors, and I think about 20% of them are any good.
So,
thank you for the clarity. Thank you for the clarity.
Let me support that opinion from a guy who's only been a realtor for 41 years.
Okay.
There are those of us that are realtors and are wholesalers The other thing that's interesting about we realtors is there's a provision of our code of ethics that says I can't criticize another realtor. Now, I'm having a hard time finding any other industry that has to have a code of ethics to prohibit any member of that industry from criticizing any other member. I think that says a lot right there. But since there is that provision in the code of ethics, I have to shut up at this point
Wow.
and say absolutely nothing. So, but there are those of we realtors that, oh, but the one thing I can tell you is that 10% of realtors do 90% of the business.
Yep. And that's,
So,
and let me tell you, a good realtor is worth their weight in gold. And a bad realtor is like a rock dragging you down. They come to the closing, they don't know what they're doing. All they really care about is their check, but they generally will make up some dumbass question just to try to look good in front of their client. Usually whatever they're asking, it makes the lawyer look bad, and we had to sit there and grin and take it and pretend like we give a good answer. You know, but there you
but
have
once
it.
again, to comply with my code of ethics, I have to keep my mouth
Okay.
shut. Thank you.
Okay, so getting messages that I need to wind up because I'm over time. I appreciate your attention and your questions, guys. I was kind of dreading doing this because it is a boring topic, but you know, once I got into it and y'all had questions, I appreciate your attention. And it's very dry, but it is very important to your life if you're a wholesaler. So thank you so much for being here.
Thanks, everybody.
Thanks, Kathy.
Thanks, Kath. Great info.